Hello everyone, I'm Darren Lewis, I'm a barrister at St John's Chambers, and we're here today to talk about two of the exceptions to qualified one-way cost shifting, the traditional route, the most common route of finding a fundamental dishonesty or a Section 57 dismissal, and the less common, but I think becoming more common route of a wasted costs finding just to circumvent the whole process. In terms of housekeeping, this is the usual bit when I'm in chambers that I'm warning you where the fire exits are. In this instance, I want to let you know that there is, if you move your cursor down on the screen that I appear in, a little bar will appear, and on the right-hand side of that bar is the capacity to just hang up on me and escape and not hear any more about the topic. But right next to that will be two what looks like conversation boxes. If you tick that, that will let you see a comment section, and it will let you comment yourself and ask questions as I go along, and I will address those questions at the end. Hopefully that's of help. I've also been asked to let you know that there'll be a feedback form at the end of this talk where you can say what was good, what was bad, what you want to hear more of. I would encourage you to fill that in. I normally joke that if you don't fill it in, we get sent to Carlisle, and I really don't want that. But at the moment, frankly, I would be happy to be sent to court anywhere. So in any event, do please fill it in. This talk assumes a basic knowledge of the rules for qualified one-way cost shifting and for fundamental dishonesty in Section 57, and because they've been changed since the 1st of April 2013 for FD, 2015 for Section 57, and I'll delve a little bit deeper into wasted costs in due course. What I will say is there's no need to take copious notes or anything like that. I'm a bit old school, and so I've put together a handout which is going to be emailed to all participants at the end of this process. That will have some case quotations and various other citations which are hopefully helpful to you in correspondence with the other side or applications before the court. So no need to take detailed notes. In terms of where we start, this is where we find out how good I am at PowerPoint. Yeah. So the first and obvious point, but it's a point which is worth making, is FD is an exception to the qualified one-way cost shifting regime where permission is required. I think that's important because often it's a point that's missed, that it's not enough just to simply have a finding that the claimant's been dishonest. Fundamentally, you have to do something more, which is convince the court that ultimately permission should be granted. Now, some courts take this as a read, and it's a very easy step, and I think it's probably it's even easier if you've made a judge sit through hours and hours of evidence that they ultimately find is dishonest. But it's not always the case, and so this talk is going to provide a few hints and tips to hopefully tip things in your favour if you're a defendant, and if you're a claimant, to be alive to some of the features that might mean that your client will escape permission being granted for costs to be enforced against them directly. I've extracted there the textbook definition from Gosling and Screwfix of what FD is, and I'm not going to go through that. It'll be in the handout, and you'll know it in any event. What I have here is the definition as set out in Section 57 of the Criminal Justice and Courts Act 2015. The points that I want to emphasise there is subparagraph 4, which is that ultimately the obligation is on the judge, even if it's carrying out a Section 57 dismissal, to assess the quantum that the honest damages in this case. And thereafter at 5, that sum is offset against the cost sum that's ultimately awarded. And I think that's an important point to emphasise, because we aren't in, when we talk about getting around the QOCS regime, we aren't in a scenario, or we're simply ending up with exactly the same results that we got pre-QOCS. As I've already said, in FD, you need a positive finding that permission, or a positive granting of permission before you get your costs. In Section 57, you're going to have what would be the honest damages offset against your costs. And as we will touch on in wasted costs under Section 51, ultimately you're going to have to prove a causal link between the improper, negligent or abusive behaviour and ultimately the costs that you're asking for. So all too often I see just a cost schedule for the whole litigation. That's not how it works. It's that which has been generated by the offending behaviour. In terms of a few headline procedural changes, this is only relevant to those of you who have litigation where there is a mixed element to your case. So ultimately, for example, if you have a PI case where there's also a defamation element, which was the case in Brown and Commissioner of Police for the Metropolis, or as I had the other day, a case which was ultimately about the dreaded GDPR, but the consequences were person injury consequences, and there were various other claims arising from the GDPR. You have a mixed case, and you will need to look at Practice Direction 44, which has been amended in the most recent changes to the White Book, to clarify matters which were thought to be unclear in the case of Brown. In terms of fundamental dishonesty, and I think probably in terms of all litigation at the moment, one of the things solicitors are asking themselves is, how do we actually get the case heard? I mean, it's all well and good hearing about all these changes, but we want the actual case to get in front of a judge. And what was happening all too often in FD cases or Section 57 type cases at the start of lockdown, at the start of social distancing, was that the Lord Chief Justice's guidelines basically said if a case was hotly contested, it probably shouldn't happen remotely, and they were being adjourned off left, right and centre. And there are some courts which are still enforcing that quite strictly. I suspect the Lord Chief Justice's guidance has softened for other areas, and I suspect we're going to probably see changes very soon in PI and clinical negligence. But in any event, there's a useful case which I've certainly seen discussed in chambers and is I've certainly cited at case management hearings, which is the case of a local authority and SX, which is a 2020 case. It's a family case, so it comes with the caveat that, of course, they have their own procedural rules, but it cites a 2018 case before the Court of Appeal, which ultimately says that merely assessing demeanour is not a powerful tool in assessing the honesty or the dishonesty of a person. That demeanour is to be deprecated. It's not the most important issue. The Court of Appeal Authority is also interesting, as is the High Court Authority, in saying, well, it isn't a bar to a fair trial if you're giving evidence via video link. In fact, it's quite common in family cases, it's quite common in criminal cases. And given what we now know about deprecating demeanour as a powerful factor in assessing dishonesty, this is hopefully a useful case, which I've quoted and you'll find in the handout, to assist you in getting your case listed. Ultimately, if you're wanting to resist that, you want your hearing in person, you cite the existing Lord Chief Justice's guidelines, and you know, there will be various other issues, including technological ability of your clients, etc. And there we go. Important procedural changes in relation to FD and the potential of contempt of court proceedings arising out of an FD or a Section 57 finding. Most of you will now be aware that Press Direction 22 and 32 of the CPR have been amended in the most recent round of amendments. It now prescribes a form of words that you must use in both statements of truth and at witness statements to set out that the claimant is aware, or rather actually in this instance both parties are aware of the, or all witnesses rather, are aware of the potential for contempt of court proceedings if dishonest statements are made. That is of course plainly relevant for FD and Section 57 cases, and whilst not every FD and Section 57 finding will result in a contempt of court proceedings, it is a fairly clear signal that the senior courts and the Civil Justice Committee are trying to push through a change in culture where signing your name to a false statement or a false head of loss is going to have very serious consequences. I've extracted and it's on the screen in front of you, and it's on the handout, the actual form of words. There's no variation. You need to copy and paste it into your pre-existing pro forma documents and use that from now on. This idea of a change of culture, or pushing culture for both litigants but also for the district judges and circuit judges, has been something that the senior courts have been emphasising since they've had the chance to grapple with FD cases. And one of the authorities that I always bring along to court with me, particularly when I think I've got a judge who is a bit reluctant to make an FD finding or a Section 57 finding, is Melody and Cambridge Vibration Maintenance Services. That's a case where actually in fairly strident terms the High Court said of His Honour Judge Main QC that he adopted a much too benevolent approach to evidence from a claimant, which could be demonstrated to be inconsistent, unreliable, and on occasions simply untruthful. And it went on to spell out some of the features that we will nearly always see in our FD cases or a Section 57 cases, which is ultimately a number of significant inconsistencies of medical evidence, medical legal experts not being told the full story, and that being key and relevant to the medical legal expert's diagnosis. In fact, the appeal court went a stage further at paragraph 46 and said, actually, taking these inconsistencies and how important the medical evidence and your account and history is to the medical evidence. In that instance, in a whiplash case, the court should have simply disbelieved his evidence in totality. So it's one of those instances that, and I seem to see it again and again in FD and Section 57 cases, where the higher courts are saying that what used to be the norm when when QOCS came in and FD came in, of fudging these issues, and it was certainly the norm to fudge dishonesty before QOCS in the civil courts more generally, that it's not being tolerated. They want the district judges and circuit judges to properly grapple with this issue. Leading authority on Section 57 is LOCOG and Sinfield. I've already put up the language of Section 57, and it'll be in the handout that will be sent out to you. But Sinfield spells out what the court is ultimately looking for, which is that the head of claim and the exaggeration of that head of claim or the factual account has substantially affected the presentation of the case, either in respects of liability and quantum. I've seen other commentators say really Section 57 is only for quantum, and that's not right. It's liability and quantum, and it's an important point to note. The other thing I think that's really important in terms of Sinfield, when we look at the language of substantially affected, is ultimately how much of the case was ultimately found to be dishonest. Because in Sinfield, where they say what we're looking for and what we mean by substantially affected is it goes to the root or it goes to the heart of litigation, the offending head of loss, the gardening claim, only made up 28% of the value of the total litigation. it was 42% or thereabouts, 42% of the overall value of the claim. Forgive me, of the special damages, but 28% of the overall value of the claim. Again, I think that's a useful defendant case and not very helpful for claimants in showing how the senior court's view, and in that instance upholding the court immediately beneath on this point, that ultimately something as small as 28% is still considered substantial and has a substantial impact. Again, early authorities had talked about matters which were a corollary to the litigation or a minor hived off head of damages. One would think actually that a gardening claim might fall into that category. Historically, before QOCS and FD and Section 57, they were nearly always used as an element of make weight, wrongly, obviously, for the purposes of negotiation. But Sinfield makes perfectly clear, certainly on that factual matrix, and it is case specific, that was enough for it to be considered substantial impact. What is and what isn't? Well, until we get more authorities on this, and until we get more examples, we don't know. But certainly the examples that are being produced at the moment, I think, again, all tend towards the defendant friendly. The other thing that's relevant in terms of Sinfield and is relevant in terms of Grant and Newport, which is a case from this year, is that whilst it was only 28% of the case that was dishonest, and therefore the majority of it that was considered honest damages, that in itself wasn't considered sufficient to satisfy the last element, the last line of defence for a claimant in a Section 57 case, which is substantial injustice, that if you strike out this claim, there is substantial injustice to me as the claimant. So Sinfield makes clear that the fact that the majority of damages are honest, tough, that isn't substantial injustice. Grant and Newport is interesting. Again, it shows just across the border the approach to Section 57. There, honest damages amounted to £83,000, which included £31,000 of legitimate past loss of earnings, and a Blaemire award of £15,000. The exaggeration there was of current symptoms and symptoms going forward, and ultimately there was a claim in excess of £300,000. But she was a claimant who was seen to be in significant financial hardship. She was a cleaner. And she was a claimant who was seen to have a continuing risk, and it was higher than negligible, to my recollection, of osteoarthritis. Claimant's barrister didn't argue substantial injustice there. I won't name who the claimant's barrister is, but it's a fairly feisty London PI barrister. And it goes to show that you're looking for something really exceptional as a claimant if you're going to argue substantial injustice. I was at a PIVA talk with Mr. Justice Eads last week, and I asked the question again, have you come across any instances of substantial injustice or first instance discussion with judges? And his answer was no. But one of the examples that was cited is the possibility of, say, a claimant who's exaggerated the rest of his claim. But there is a legitimate claim, seriously injured, for adaptation of houses in order to actually live independently with a family. Again, there's no case law on this, so it's a developing area. But thus far, a lot of things that you might consider substantial injustice, someone with extreme financial hardship, or a majority of honest damages aren't sufficient to pass the test. Two cases, and trying to pick up speed a little, that illustrate the issue of persistence of dishonesty in Section 57. That are very useful. McDade and Walsall, which is a circuit judge level case for Her Honour Judge Truman in Birmingham. That was a case where the claimant's counsel read defendant's skeleton argument, conference with his client, realised that in looking at the medical evidence, there was a head of loss which was just unsustainable, that it seemed grossly exaggerated, advised his client to abandon that head of loss at trial, and did in fact abandon that head of loss at trial. It wasn't pursued, and ultimately Her Honour Judge Truman said it doesn't matter that it's not been pursued at the substantive hearing. It will still have had a substantial effect on litigation. And ultimately there was a Section 57 dismissal. So that kind of process late in the day just isn't going to cut it. That was the most senior authority on persistence until I think it was March this year, when the High Court in Roberts and Keeson and another said much the same thing. That was a case where at first instance the judge had basically fudged the issue of Section 57 and FD. The claimant had, that was a relatively low value car, RTA, and there was a claim for pre-accident value, and it had emerged through a bit of digging that in fact the claimant was still in possession of the car and had fixed it up, and fixed it up for a lot cheaper than the PAV, and had put in a second statement where he effectively corrected, so it wasn't even at the court door like McDade. A statement had been put in where he addressed the issue. It was a fairly lame excuse, but it was an excuse nonetheless, and it was clear it wasn't being pursued. Mr. Justice Lay, and slightly uncomfortably for the first instance recorder, said, paragraph 55, I do not agree with the recorder that the correct test is one of persistence in dishonesty, because that does not reflect the language of 57(1)(b). There's no requirement that the claimant persists in his dishonesty, but moreover, he says 56, in any case, the recorder rather ducked the issue of whether the claimant did persist in his dishonesty, and made no findings about this idea of being flushed out, that ultimately it was the defendant's, solicitors and insurers' legwork that followed this hunch to ultimately bottom out the fact that the car was still very much in his possession, and then the issue about pre-accident value and repair emerged. No findings of fact there, which again the court was very surprised about. Frankly, it wouldn't have mattered whether there was a finding about being flushed out or not, because it's this idea that is there a substantial effect on litigation, not is it carrying on at trial. So an important case, because it's the more senior courts underlining the practice that we're seeing at circuit judge level. Ultimately, I've already touched on the idea that you've got to get your permission in FD cases. And ultimately, there is just the sort of the moral hurdle you have to overcome, which is that judges traditionally don't like the idea of ordering costs against litigants rather than their insurers, sometimes for substantial amounts of money, and often against people of relatively limited means. In terms of defendant tactics, and I'm not going to cover what you would do in terms of surveillance evidence or waiting for witness statements or medical legal evidence. You know what you're doing there. But it's far simpler than that. It's point number one, check your defence covers you. The case is Howlett and Davis, which isn't in the handout and isn't in the notes, though most of you will know it, but it's worth scrolling that down, which says that ultimately the threshold for what the defence needs to say is relatively low. You need to put the claimant on notice that his or her account is going to be tested, and the credibility of that account is going to be tested. 99 out of 100 defences should cover it. If you're someone pleading a defence, you should make it perfectly clear that that is the case, that the claimant's account is going to be tested. I still see some defences in a post QOCS and an FD world where that hasn't been done, and you do need to check as soon as there's the whiff of dishonesty as a defendant to see whether your defence is sufficient, or you better start seeking permission to amend very quickly. The next thing you need to do is assess how greedy the other side are and how bullish you are. if you're certain you're bound to get an FD finding, I've never been certain I'm bound to get an FD finding, given the reluctance of some judges, then you don't need to engage in any other stages. You sit there and you wait for your FD finding or the claimant to withdraw and apply to restore. If you think that your chances are less than absolute certain, you need to judge how greedy the claimant is. I typically advise solicitors to make a drop hands offer as soon as an FD issue arises. You don't even need to say why you're making the drop hands offer or that it's to do with FD, but it is certainly helpful. And you need to set, I think, what I found useful, a deadline past which the offer is no longer on the table. And expressly, and this is important, ask for confirmation that the claimant's been told of the consequences of an FD finding and a Section 57 dismissal. Typically, again, if you're feeling confident that the claimant's going to be greedy and not see sense, I would make that offer again a month before trial, again setting the deadline, again asking expressly for written confirmation that the claimant's been informed of the consequences of persisting in their dishonesty. And in that instance, setting out an estimate of your costs to trial, or if you're in a multi-track trial, your precedent H. And then if you are feeling still uncertain, confident that the claimant is going to be greedy and it looks like it's going to run to court, whatever happens, I would repeat that. And I have had instances where we've repeated that drop hands offer to expire the Friday before the week of trial. And the purpose of that is ultimately that it empowers your counsel at trial when you've got your FD finding to say, look, judge, the defendants have done all they can in the circumstances to give this claimant an out and a saving of face without having any cost consequences, and they've persisted and they've continued to pursue it, and ultimately here we are. In those cases where you've done that, and it does require you to be bullish, and I do think sometimes insurers don't like the idea of offering a drop hands when they think they've got a good FD argument. It's just one of those things that I think helps tip you over into definitely getting permission, and more importantly, definitely getting more of your costs at the end of the day, because again, judges will sometimes, in feeling sympathetic, look for ways to minimise the cost that the claimant's ultimately paying. But if they've shown themselves to be A, dishonest, and B, have had an honourable way out and not taken it, then you'll get a less sympathetic judge. In terms of claimants, and very, very quickly, there's no substitute for getting the full medical evidence early, the full medical records early. One of the joys of, if there are any joys between lockdown and us not being in our office, is that a lot of us are investing in new PDF software, OCR. These are all things as a bit of a technological dinosaur that I've been learning about very, very quickly. And one of the great things about OCR is if you can scan in typed documents, you can actually search for break, shoulder, neck, RTA, and turn out information from years back in a way that would have taken hours and hours of trawling through medical records previously. So your life is being made a lot easier, and as a claimant solicitor, I would say definitely get those early and definitely go through that exercise. Similarly, and it's an advert for my colleagues who do more claimant work than I do, instruct counsel early. If you've got a high value FD case or a multi-track case, there's no excuse for not doing it if there's any whiff of fundamental dishonesty and evidence being explored and tested. And also finally, and I think this is a point I can't emphasize enough for claimant solicitors, to sit down and properly advise your clients of the consequences of a finding of fundamental dishonesty or exaggeration. Some of the most painful cases I see are instances where my skeleton argument lands on the desk of my opponent the night before. They sit down and conference with your client without you there at trial, and ultimately they're hearing, perhaps for the first time or any meaningful sense, that they could be on the hook for in excess of 10,000, in excess of 15, 20, 30,000 pounds worth of costs. And there is a balk factor where they will either seek to discontinue or drop hands, and if the other side's barrister aren't willing to do that, it will affect and impact the quality of their evidence. So engage with this as quickly as you can. Moving on to wasted costs, the headline here is none of the precedents have been displaced. None of the senior courts rulings have changed, but there is a definite change in culture at the coalface. There was, I think, since QOCS has been introduced, anecdotally, an increase in instances where I am instructed or I feel able to seek permission for a show cause hearing to be set down. And I think anecdotally there is an increase in willingness for judges to make that finding at a show cause hearing and ultimately order wasted costs. No senior, as I've already said, courts authorities on this change, but there's a number of first instance authorities around the country which have been bootstrapped by defendants, and that has impacted the culture. That march towards a more generous wasted costs environment was slightly arrested in a case of this year, which is Walker Preston Solicitors and Department of Transport, which actually analyses the senior courts authorities, and whilst it's only a circuit judge level appeal, is admirable in summarising those and carving out three potential categories of hopeless case and applying wasted costs rules to them. In the handout that's in front of you, or will be in front of you, and the screen that's in front of you, I've extracted section 51. The most important thing I can highlight there is subparagraph 7a. It's the phrase "as a result of." It's something I've already touched on, which is that you don't just get your costs, you don't get all the defendant's costs as you would pre-QOCS if you won. You really are having to prove a causative link between the improper, unreasonable and negligent act and your costs. So, for example, in a disease case, that will often mean, in a multi-track disease case, medico-legal costs are out. Very often in engineering evidence, that will also be out in terms of costs. So your costs will be much later in the litigation process. CPR 46.8 and PD 46 set out the procedure. I'm not going to set that out in detail, but effectively there is a fairly high standard that the court has to have before it sets down a show cause, which is that the evidence before it, if unanswered, would lead to a wasted cost finding. And ultimately, they're obliged to give the solicitor, or in some instances the barrister, the opportunity to file evidence as to why they ought not to be a wasted costs order, or rather what the evidential position is. I've extracted a number of paragraphs from Rydhall and Horsfield and also Dempsey, which I'm not going to go through in detail, but I think that there are useful quotations, and if you're a claimant faced with or rather a respondent to a wasted costs application, they are useful to send to the other side in correspondence and send to the court. Ultimately, it makes clear that the burden is very much on the applicant in these circumstances. It also makes clear that privilege obviously applies, attorney-client privilege applies in this field, and very often the respondent solicitor will not have his client's permission to disclose advice, correspondence, anything like that. And that puts the respondent solicitor to a grave disadvantage, and ultimately that disadvantage is resolved by them being given the benefit of the doubt. Rydhall also makes clear that improper doesn't require negligence. It doesn't even require a breach of professional standards that would put you before the SRA or the Bar Standards Board, but merely conduct that most professionals would rightly deprecate and would be stigmatized, although it might not violate the professional code. It also emphasises, again, you can't just assume that because a hopeless case has been run to court, that ultimately it's the solicitor's fault, that you have to prove something more than that. But it does say that you go through an exercise of looking at whether it would be improper for the case on the evidence that's available, the statutory cause of action, for a solicitor to take that matter towards court. A gloss is put on that slightly in terms of Dempsey, which is useful, I think, for both claimants and defendants. Again, I've extracted the relevant paragraphs. I'm not going to read through them all. But ultimately, that's really the case where hopelessness was much more developed. And Dempsey was a case where even if the claimant's evidence is taken at its absolute highest, which it was, in law, he couldn't succeed. And in that instance, that is a case for a wasted costs application, because it was hopeless from its start, effectively. What Lord Justice Mance makes clear at paragraph 41 is that ultimately it's a question in assessing whether there has been improper conduct, that it will be typically resolved by a general inquiry as to whether or not the legal representative pursued a claim or a defence which no reasonably competent practitioner could have done. Mayfield and Matthews is one of those cases that really evidences a change in culture. Again, it's first instance, so it's not binding, but it does exemplify the approach here, and it's a fairly typical snapshot for those of us who do, as I do, disease litigation, which is that the claimant could make his noise claim out on his audiological evidence. He needed an engineer to ultimately prove causation and noise emission level. And in Mayfield, what was clear was that the engineer, the jointly instructed engineer, said, "Well, look, I don't have any measurements because the factory no longer exists. On the claimant's evidence that's before me and all of the other surrounding circumstances, I can't say he's been in the premises for sufficient time to have a negligent and a causative noise emission level. I also can't say in terms of breach that he was in certain parts of these premises for sufficient time for him to have an injurious dose." And the matter ran to trial. And those of you who are robust in pursuing your litigation might seem bits incredulous that it did, but it's actually not that uncommon in the circumstances for that to happen. There's the hope, at least, well, maybe we'll just get a judge, there'll be no cost consequences for the claimant to run it to trial, and we'll get a judge who won't run or make a wasted costs show cause hearing. And ultimately what the judge said there, and I think it's a useful little case if you find yourself in these common circumstances, is to say, well, look, the only way that the gap could be plugged is if either the claimant gave fresh evidence, and he says that wasn't going to happen because the engineer would need to comment on that evidence, which plainly they weren't in a position to do in a knockabout fast-track disease case. 2, one of the defendants' counsel was stupid enough to cross-examine and leave a route in to call new evidence. Or 3, that the claimant's solicitors were effectively hoping defendant solicitors would just say, look, go away, here's some money. And he makes clear that certainly the last point would be an abuse of process, and you can't assume 1 or 2. And there a wasted costs order was made. Gargan, and very quickly, I move on to, excuse me, it's a pint glass, but it's definitely water with some tea in it. 77, which is where the learned judge carves out or spells out the 3 class of hopeless cases. 77.1, the Dempsey case, where you're bound to fail in law regardless. 72, the Mayfield type case, where you proceeded, but you've got no evidence to satisfy your case at all. and 77.3, where frankly it's absolutely fanciful, something weird or wonderful may come out. But, on any estimation, you're not going to win. And what is made clear there is if you're in the Dempsey or the Mayfield category, hopeless in law or hopeless in evidence that it's just not sustainable in the slightest, you may get your wasted costs. You may get a wasted costs order against you there as a solicitor. But in the final category, so that you've a very weak case or utterly unattractive, but pursue it to trial, that isn't sufficient. This is all with various caveats and all with the warning, of course, that, as I say, the burden is on the applicant in the examples that I've given the defendant to prove the improper conduct. And whilst, as I've already emphasised, Rydhal says you have attorney-client privilege, and often that is resolved in the respondent solicitor's favour, Mayfield and indeed other low-level authorities that I've seen, non-binding authorities, consistently point out that it's not a fig leaf, that's that there are proper assumptions of the benefit of the doubt. But if there's no, for example, exploration in a witness statement that says, I asked my client for permission or waiver of attorney-client privilege, or I explored it, or I tried to get hold of him or her, if there's nothing in that regard, then the applicant's barrister is going to have some persuasive argument. So it's a very simple step to ask, and if they've not waived privilege, they've not waived privilege. I think there's also something to be said about the assertion that whilst you can't disclose the content of advice, you can disclose that you have advised the claimant. And we know that from Preston H and the cost process that doesn't breach privilege. We have, or we intend to, advise our client. So ultimately, there are still steps that applicants can use to try and address the benefit of the doubt being given. I'm mindful of the time, and I'm mindful that I want to open up for questions. Hopefully it's been useful, but if you have any questions, do feel free to ask now. And I think we're going to remove the screen sharing so that I can see the questions. Let's see, there we go. Okay. Let me see. Okay. Peter asks, have I encountered any FD findings being handed down following a remote hearing? I have not, but one of my colleagues has. And obviously a first instance decision, but yes, ultimately courts are willing to do that. And given what the family case, a local authority says, they're perfectly entitled, it would appear credibly to do that. Anonymous asks, given the changes in rules on witness statements, is it worth getting a supplemental statement from your client addressing she was made aware of the new amendment re contempt, and could we put Part 18s after exchange to see solicitors to see if amendments to rules were put to the claimant? Just thinking out loud and trying to weed out early if third-party solicitors have a client on board. If the witness statement was made before the rule changes, there is no need to amend. I think that it's usually not appropriate to ask in Part 18s, I would aver, whether the issue of contempt or the consequences of FD have been explained to the claimant. But I think in without prejudice correspondence, it's perfectly proper. In fact, in open correspondence, it's perfectly proper I don't think a court, for example, would order that as a Part 18 question. Anonymous says, does FD need to be established against a claimant in order to pursue wasted costs against their instructed solicitor? No, it doesn't at all. One of the interesting things is, and the reason why I started to do this a lot more, was that I was getting cases where it was on the one hand a hopeless case, had it been, and there was no evidence to support it. And then on the other, the claimant had actually lied bluntly and grossly exaggerated. And in those instances, it's an interesting case, and I think it's some of those cases that have driven courts being more willing to make a wasted cost finding, because they have on the one hand a claimant of limited means, and on another a solicitor with a professional insurance, rightly or wrongly. But no, there's no need for an FD finding for a wasted cost order. And in fact, very often, some of frankly, the sadder cases that I see in disease litigation are cases where, frankly, the claimant is being absolutely straight up, entirely honest, but he's gone to an outfit that just should have told him a long time ago it's a non-starter. And judges are often very, very sympathetic and very, very angry. Very sympathetic with claimants and very angry with the case managers or solicitors who've pushed this person with all the stress of litigation to court, where, you know, the first question, it all falls apart. Tom asks, with regard to the recent changes to PD 22, is it sufficient to include the contempt wording at the start of the statement rather than in the statement of truth, and then to swear the statement of truth with the previous wording? The language, as I understand it, is prescriptive, so you must have the new statement of truth if your statement of truth was drafted and is dated, more importantly, after the rule changes. You must have the new language. So it's definitely one to change. If you've got pro formas on your system, you've got to change it now. Gary asks, what would be the position if a claimant simply discontinued the matter where an FD allegation is made? Well, defendants can apply to restore a matter that's been discontinued, and I've not touched on that because we had so little time, but there is a power to apply to restore. And courts are more willing, certainly in the Western Circuit and the Welsh Circuit and the Midland Circuit, where I tend to appear, are more willing to do that than they ever were previously. The fact is, if it's very early doors, very, very early doors, most defendants would probably not pursue it, but I mean, unless there's a really flagrant dishonesty. And so when I'm advising defendants to make a drop hands offer, what they're ultimately doing to the claimant solicitors is making a drop hands offer and giving an undertaking that they won't apply to restore in the circumstances. And that's an important point for you as claimant solicitors, that it's not enough to drop hands. Properly, you should be asking for a drop hands and asking for an undertaking from the defendant solicitors that they're not going to apply to restore. Anonymous, you mentioned at the end of the FD section claimants who would learn consequences of FD for the first time at trial. Could the claimant admitting this at trial lead to a wasted costs order? Potentially. I mean, you now have a professional duty as a solicitor, given the changes to PD 22, have a professional duty to explain the consequences of a dishonest statement to your client. That is a professional obligation. And if you've not done that and they've signed that statement, I think you're going to be in more difficult territory. I think it's fairly unattractive, because you then get to the argument about consequences, the actual causative link, what generated these costs. Was it the person who'd come to court deliberately to lie, or the person who hadn't advised them they shouldn't lie? And it's not a massively attractive position. I think a defendant would have problems possibly with causation, but it's a possibility. I think that the court would be more, in those circumstances, would be more eager, well, would probably disbelieve the claimant. Because of course it's not a defence to say, oh, my solicitor didn't tell me I shouldn't lie. We do hope that adults will just not lie without being told that. So it would be an unattractive argument. Right, any more for any more? No? Okay, well, either that means I've bored you to death, or you've got all the answers. So thank you very much all for coming along. Please do fill in those feedback forms. For those of you who aren't signed up to our mailing list, please do so. We've got some good talks coming up from Andrew McLaughlin and Rachel Segal. And we'll, I think, be continuing to do these sort of bite-sized talks for the foreseeable future. And hope everyone's keeping relatively sane during lockdown. Thanks very much. Bye-bye.